Tips for trademarks management. User is very important in trademarks. The concept of use and non-use is essential under the trademark law of every country. Trademark registration is optional but not compulsory under the Act, and such registration is for better protection only. The definition of trademark includes a registered as well as unregistered mark. Supreme Court. Trademark ownership is determined by priority in use. To own a trademark, you must simply use it in the commercial market. Mere registration will not confer any rights on the registered mark holder unless it is being commercially used. A trader or manufacturer can acquire goodwill over a mark in respect of particular goods and services as per the accounting concepts and standards by virtue of continuous use of such mark, that is, on the basis of sales turnover, but not on the basis of mere registration alone. The Trademarks Act 1999 classified the goods and services into 45 classes as per International Classification of Goods and Services. Hence, trademark application should be filled in a particular class for particular goods and services for which the mark is actually being used or proposed to be used. A trader or manufacturer should not be permitted to enjoy monopoly rights over a particular trademark in respect of all the goods in all the classes. Supreme Court. Expectation to the rule is well-known trademark. For example, Pepsi, Coca-Cola, etc. Use of a mark means the use of printed or other visual representation of the mark. Section 2 of B, such as invoice copies, brochure, price list, catalog, directories, advertisements, labels, packaging materials, and e-display, etc. Mere filling of trademark application will not confer any rights on the applicant. Supreme Court. Priority in adoption and use prevails over priority in registration. See 34 of Trademarks Act 1999 at Mumbai High Court. Non-user of a registered trademark will entitle for cancellation of registration. Trademark registration could not be granted across the counter in a single day or month. It is a legal process and it will take at least 10 to 12 months to complete the process of final registration. If your mark is opposed by any third party after advertisement or publication in Trademarks Journal, then it will take further 2 to 3 years to dispose the opposition proceedings as per the present scenario in the Indian Trademarks Registry. If any mark is being continuously used but refused, lack of distinctiveness or similar mark for advertisement in Trademarks Journal, or not renewed, not payment of renewal fee, or abandoned non-prosecution of application, the proprietor of such mark will not lose any proprietary rights under the common law rights, but only statutory rights under the Trademarks Act 1999 could not be claimed. There is no bar in filling second or subsequent application for the same mark in respect of particular goods or services on the basis of acquired distinctiveness or longer user or honest concurrent user in order to claim registration of trademark subject to proof of continuous use of the mark even after refusal to advertise in journal or abandon application or non-renewal of registered mark in section 12. Trafficking in a trademark is totally prohibited. It means an act of getting a mark registered without any bona fide intention to use it in relation to any goods or services, but to deal with the mark itself to gain monetary benefit by its sale. The registrar of trademarks is vested with powers under the Act to grant conditional registration in respect of a particular state or region or territory or mode or area. That is, the term limitations defined under Section 2 of 1 of the Act. The Registrar of Trademarks is not a licensing authority or branding authority to grant permission to adopt or use a particular trademark except whether to grant registration or not. Any order of refusal by him is appealable before the High Court. Brand is a commercial terminology and the term trademark is a legal terminology, but both have the same meaning. When you commercialize a word or name with your packaging or goods or services, it will be termed as brand. And when you take steps to protect your brand under the statute Trademarks Act, it will be termed as trademark. All user brands are trademarks, but all non-user trademarks are not brands.